it because it stands for the proposition that we submit. Closure decisions are to be made by the trial judge on the totality of the circumstances, on the case-by-case basis, and that quote is at page 5 of our reply brief. I started with Barron, and I want to end with Barron, but I want to
Would you first address, before you get there, your opposition is suggesting that when we're dealing with juvenile types of proceedings and we're dealing with children, that we're truly dealing in a different area, and you're at a different starting place. Is that you're taking viewing it with the focus only from the parent's perspective, using MLB, the due process rights, to recognize that kind of right. At what stage, where's your response to his initial statement that you have to look at this from the juvenile perspective and what's happened historically and legally from that perspective?
And I'm happy to look at it that way, Justice Lewis, as long as it's a narrowly tailored statute that allows the court discretion to address the competing interests. I don't think it makes any great difference about what has happened historically in juvenile delinquency proceedings, which began in 1899. That's the first juvenile court in this country. The truth is juvenile proceedings are open too under the statutes. And so the presumption has grown over the years into the need for openness. So I'm not troubled at all by the history. I think actually history cuts more in our favor. But I want to go back to Barron and the end of Barron. The end of Barron, Justice Barquette's special concurrence, in which she says, talking about the need for openness, that maybe it wasn't so important to have openness in a divorce proceeding, but she says that when the issue does involve government in questions affecting the general public, then openness would be something that would be called for, and that's in her special concurrence. She talks about the involvement of the government. And Justice McDonald, dissenting, has a footnote in his dissent, and he says, I fully agree that the public has access to the evidence in criminal cases because the public, in effect, is a party to criminal cases. And then here's the important sentence, which addresses exactly what we're talking about here. Such a situation may exist in some types of civil cases. And that is this case. This is a civil case of a special nature. And the need for openness is supported by Barron and the discussion in the Supreme Court cases about the importance to the general public of having these proceedings open, with the discretion in the trial court to close portions of it when necessary.
Let me just make sure about something. You're saying, and trying to understand where the starting point is, if we presume that all trials are open, civil or criminal, you do agree, though, because the primary focus of the proceeding, dependency, termination, parental rights, is to look at the best interest of the child, that should be the focus of the compelling state interest.
The best interest of the child in making this decision, yes, should be the focus.
Thank you, counsel. Thanks to both of you for your assistance. Next case on the court's calendar is Byron Gordon versus the state of Florida. Ryan, you may proceed.
Good morning, judges. Mr. Corrente. May it please the court, I'm Nancy Ryan with the Seventh Circuit Public Defenders representing the petitioner, Byron Gordon. Mr. Gordon, as the court knows, stands convicted of 4 crimes based on a single series of events. What he did, I would like to say that Mr. Gordon adamantly maintains his innocence and has done it all times in this proceeding, but he does stand convicted of walking up to the victim in this case, pulling a gun on him, demanding money. When the victim resisted, the perpetrator shot the gun once, causing serious injury to the victim, and then took the victim's money. Based on that series of events, Mr. Gordon stands convicted of armed robbery, we concede that one, and of 3 additional offenses, which are causing bodily injury during the course of a felony, attempted first-degree murder, and aggravated battery.
do agree that attempted first-degree murder and armed robbery are at least separate offenses.
No, Judge, we are going to attempt to argue that under sermons they should be treated the same. We do make some concessions, Your Honor. We concede that under strict Blockberger versus United States analysis, all 4 convictions would stand. We also concede that the armed robbery and one of the other offenses can stand.
That's what I thought I was asking. So the attempted first-degree murder would stand with the armed robbery.
Correct. Those 2 can stand. The state appears to be expecting, in this case, a frontal assault on its new statute causing bodily injury during a felony. Our position is that the subsection of that statute involved in this case, which is subsection 1 of the 1997 version, which is different from the current version, is in no way an unconstitutional statute. It's not a real problem. In that statute, the legislature said if you commit one of a series of enumerated offenses and during the course of committing that offense, cause another person bodily injury, then you're guilty of a first-degree felony for the battery. They don't want anybody walking away from a potential felony murder situation with only a simple battery conviction or only a third-degree felony aggravated battery conviction. They're making it a first-degree felony in all cases. We don't object to that. I do not object to the state keeping that conviction and the armed robbery conviction.
What subsection of 775.021 do you maintain makes these the same offense? Is this an offense which requires identical elements of proof? Is this an offense which is in degrees, or is this an offense which is a lesser included offense?
That one's none of the above. Our position is that the state can keep the armed robbery conviction and the felony causing bodily injury conviction.
Okay, I'm talking about the 3 that all involve the shooting.
Correct.
First degree murder, the felony, the bodily harm during the felony, and the aggravated battery. Okay, you're maintaining that the aggravated battery and the bodily injury during the course of a felony are subsumed under the first degree attempted murder, correct?
Judge, our position is that they are mere degree variants on the same core offense.
Okay, so section 2,
yes.
Subsection 2 of that statute is what you are pegging this on.
Yes, Your Honor.
Offenses which are degrees of the same offense as provided by statute.
Yes, Your Honor, and since you quote that language, I'll acknowledge the difference between that language and this court's construction of it in the line of cases starting with sermons. As the court knows, in 1994, well, as the court knows, let me start earlier. Back in 87, this court decided the ill-fated Carawan versus State case. The legislature came back immediately and said, no, we do not want you phrasing double jeopardy in broad terms. We want you to look at Blockberger analysis first, and we want you to look at these 3 specific exceptions. This court in 94, in sermons at the urging of a very persuasive public defender, broadly construed the language we're relying on today, which is the exception for degree offenses as provided by statute. This court read that to mean wherever 2 offenses are mere degree variants on the same core offense, then 2 convictions based on the same act cannot stand where the offenses are mere degree variants on the same core offenses. Judges, when I saw that...
Maintain your position and still honor Blockberger.
Oh, yes, Judge. Yes, Judge. Sermons is not inconsistent with Blockberger.
Let me throw something else into the mix. The legislative pronouncement that if 2 crimes can flow out of it, it's legislative intent that you should have as many crimes as you can get out of it.
Correct, Judge.
Now, couple that with Blockberger, and you still don't have a problem?
No, Judge, not with these 4 offenses. But our entire argument today is based on the line of cases which begins with sermons and which we submit are correct.
You started out conceding that if you apply just a strict Blockberger analysis, that you lose.
Yes, Judge.
That is, that you agree that that test is all right.
Yes, Judge.
Okay.
But this court has not followed a strict Blockberger analysis since 1994 when it decided sermons. Our position is that sermons is correct. And
well, MP was a pretty strict Blockberger analysis, was it not?
It was, Judge, because the no sermons issue arose on the facts of MP.
But, I mean, we're dealing here with an analysis out of the 5th District, which attempts to give meaning to what this court held in MP as to the fact that you look at different elements, and when you look at attempted murder and you look at these other counts, they're different elements, aren't there?
Yes, Judge. As we conceded readily, if you apply strict Blockberger analysis, as you ended up doing in
Well,
MP.
if you apply MP, that's what you end up with.
Judge, my position is that MP is a correct application of law because no sermons issue arose in MP. MP involved two offenses, one of which was carrying a concealed weapon, and the other was possession of a firearm by a minor. And the legislature in the latter statute said, this is separate to and in addition to any other statute. It was clearly the legislature's intent that more than one conviction could lie on the facts presented in MP, which was a child being caught with a gun.
We've had other cases since then that Gibbs, for instance, that's applied Blockberger, attempting to wrestle with the concept of possession of drugs versus sale of drugs. I mean, we've got a whole line of cases now since sermons which have given life to the statutory amendment after Carawan, which applies Blockberger.
But Judge, I submit to you there's no inconsistency between the line of cases which directly apply Blockberger, including MP and Gibbs, and the sermons line of cases, because the problem that sermons recognizes is that the legislature is continually attempting to plug perceived gaps in the continuum of criminal laws. They're trying to make every harmful act a crime. They're continually adding little offenses here and there to plug up a perceived gap. Sermons isn't a good example, but one of the cases that were decided after sermons, Joseph Thompson involved a sexual battery on a minor and sexual impropriety with a child in one's custody. Dennis Thompson involved theft and sale of a counterfeit substance. In both of those cases, the prosecutors took all of the possibly relevant statutes to the bank, got convictions on them all, and this court said, wait a minute, that very specific statute was intended to cover a situation where maybe the big general statutes didn't apply.
Well, how about working your way through? We're talking a lot about general law and Blockberger and everything. How about working your way through? You've taken armed robbery off the table, is that right?
Yes, Judge.
And the certified question really then only applies to the attempted first-degree murder and then the battery and then the bodily injury. Is that during a felony charge? So how about addressing those three and why, in the context of this case, there's any problem with constitutionally convicting and punishing somebody for all three of those? And let me help you with it a little bit to as far as why it may possibly be all right. I mean, when the state's trying to convict somebody for attempted first-degree murder, even going back, if we were still applying Carawan and that theory, wouldn't it be the harm that they were trying to avoid is we don't want people going around trying to kill other people. And so if they attempt to kill other people, it's trying to avoid that they have a crime of attempted murder. Would you agree with that? I mean, isn't that what the social policy is involved there?
Judge, I think that sort of speculation is exactly what the legislature didn't like in Carawan. They didn't want this court speculating about what evils it was trying to prevent. And
well, I guess what I'm trying I'm trying to be as kind to you as I can with reference to our subsequent case law after the legislature responded to Carawan, and that indeed we have recognized that there may be instances when the strict application of Blockberger might not yield the complete answer to a question. And I'm taking really what I perceive that we've done since then and applying it to these three and seeing how it works. But would you agree, at least insofar as the evil that is sought to be avoided by the murder and attempted murder is we don't want people going around trying to kill other people?
We don't want people trying to harm other people at all. And I submit to you that...
Well, now I'm having trouble about that. Okay. In other words, you're saying that the attempted murder and the first-degree murder is just part of a broader thing of we don't want to hurt people to get hurt at all.
Judge, that's my ultimate argument, but let me please make an easier argument first,
Okay.
which is that the aggravated battery should drop out of the case here. The conviction should drop out because under Sermons, aggravated battery and causing a felony during a bodily injury.
So are you just saying that one of these three should fall out, or what?
I have an easy argument for aggravated battery dropping out. I have a harder argument for one additional offense to drop out.
Okay.
My easy argument is that aggravated battery should drop out because causing bodily injury during a felony and aggravated battery are mere degree variance on the core offense of battering another person.
Was the bodily injury alleged and proven in each of those two charges the same bodily injury in this case?
Yes, Judge. That was a single gunshot wound. All 4 offenses are predicated on a single gunshot wound.
Okay. None of these were predicated on the, if I understand it, your client was alleged and there was evidence that he also struck the victim?
Yes, Judge, he did. But
that's not a part of the bodily injury claim in these cases.
I do know it wasn't the basis for the aggravated battery. The District Court of Appeals specifically found that all 4 offenses were predicated on a single gunshot wound.
But wasn't count 2 actually charging aggravated battery causing great bodily harm with the firearm?
Yes, it was. So clearly, the punch doesn't support the aggravated battery. It doesn't support the bodily injury either because, as the District Court expressly found, there was no bodily injury from the punch. It was a quick blow.
Okay. So you're saying the bodily injury during a felony should be deleted, or the aggravated battery?
It's got to be the aggravated battery because, time out of mind, this court has held that the lesser offense drops out once the defense succeeds with a double jeopardy argument. So, judges, that's my simple argument that felony causing bodily injury and aggravated battery are both mere degree variants on the same core offense of battery. The harder argument, which I am trying unsuccessfully this morning to sell, is that attempted murder should be treated just as part of the same core group of offenses. Just really because it makes the analysis a lot easier. There have been 2 cases decided in the first DCA and the 4th DCA since the briefs were filed in these cases on felony bodily injury and attempted murder.
Are you saying, and I know you've got this all down, but we're looking at these, are you saying that the aggravated battery causing great bodily harm, which is count 3, is subsumed within causing bodily injury during a felony? Is that
Yes, Judge.
That's okay. And then now you're arguing to say both of those should be subsumed within attempted first-degree murder?
Yes, Judge.
All right, go ahead.
And the basis for that is that attempted murder should be treated just like, should be treated as if its core were battery, because if it's not, you end up with cases like Brown from the first DCA, which was decided just this last March, saying that attempted murder and causing bodily injury in the course of a felony aren't the same offense because in the second footnote, the court says, well, attempted murder is just an assault.
But going back to what Justice Anstead was asking, though, we know that with attempted first-degree murder, that what's being attempted to be punished is the attempt to kill somebody, whereas with 2 and 3, you're focusing on whether someone has actually been harmed. So why isn't that, under whichever level of double jeopardy analysis we're looking at, why shouldn't that be a separately punished, crime?
You can treat them separately. The legislature may have intended for you to treat them separately. I am suggesting that in addition to dropping out the aggravated battery in this case, one of the additional offenses should be dropped out because the legislature has just created so many crimes of which a defendant can be convicted based on the single act of harming or trying to harm another person. I submit they have the same core.
One of the things that always concerned me is one thing to get convicted of multiple offenses arising from a single act. It's a second thing to have consecutive sentences imposed. As I understand it, the judge gave consecutive sentences on count 1 and 4. Under the 5th District's analysis, would there be consecutive sentences also for the counts on 2 and 3?
There can be, Judge. Mr. Gordon is serving life on 1. I do not know whether Judge Caney plans to impose consecutive sentences when this case does ultimately.
That's the implication. It's not, even though it's arising out of a single gunshot wound, consecutive sentences can be imposed.
Correct.
But if there had been first-degree murder and he had gotten life in prison for it without the possibility of parole, would the aggravated battery and causing bodily injury be subsumed under our case law?
Yes, Judge, they would. This court has treated murder as sui generis and has said there's only going to be one murder-type conviction in any case, regardless of Blockberger, because we can't believe the legislature intended that a defendant who is saddled with a murder conviction was also intended by the legislature to have aggravated batteries and vehicular homicides and any other possible variation. I submit you should add that you should treat murders, attempted murders, and batteries as a single group of offenses with as their same core attempt to batter another person. Because I'll just ask you, if I may, my amber light has come on.
Let me ask you this before you get too far. Are you really saying that the core offense here for all three of these is that there was a battery?
Yes, Judge.
And so, because there was a battery, no matter how aggravated it was, it's all one offense?
Correct, Judge.
In essence, that's what you're arguing?
Yes, Judge. The three offenses excluding armed robbery. Yes, Judge. That is our position.
What would happen if there were two gunshots? Would there be eight crimes out of, well, 6 crimes out of this?
With this prosecutor, yes, Judge, almost certainly.
Well, no, under the law, would the law allow that of the 5th District?
Yes, Judge, I believe it would. The 5th District is very strict about dividing up incidents into separate acts and imposing allowing the state to seek and obtain the maximum number of convictions as to each act.
Would you agree that if in fact the punch that was landed on this victim had resulted in a broken nose, say, would we then have a different situation here?
I think so, Judge. I think so. Because, in that situation, arguably, yes. But the state would have a better argument. I would argue that it was a single incident involving one single person battering one single other person, and you shouldn't divide it up in time.
Because there were 2 injuries in that situation, we would not have the same argument.
Because there were 2 injuries, the state would have an additional argument. I would still be arguing that it was all just one incident, and it all just flowed from one incident into another. The 4th DCA tends to take that position, that you don't freeze the frame and put the maximum number of convictions on each frame. But that's really that issue is really not addressed much by this court's case law, and that's something where you got a lot of variety in the districts, but it doesn't really come up in this case.
Variety by conflict, or just, I mean, when you say variety, I mean, it seems like there should have to be one way that this is analyzed around the state. Where's the conflict between the 4th and the 5th?
Judge, it doesn't arise on this case because there's a single gunshot. Had there been 2, I think you would see the 5th DCA saying, well, that one was one act, one was another act, even though they were just like this. And I think my impression of the 4th District's opinions is that they're inclined more to agree with defense counsel that, well, we're not going to divide this up into 2 acts. It was a single incident.
If you wish to save some of your time, you may.
I'm just about out, yes. Thank you, Judge.
Thank you. Mr. Corrente.
Good morning, Your Honors. May it please the Court, I'm Carmen Corrente, representing the state in this case. And I think the distinguishing factor here that we have from all of the other cases that we've discussed is that the appellant in this case committed 2 clearly separate crimes. He committed an armed robbery and he attempted to kill. Most of these other cases where we are discussing double jeopardy and one is subsumed into another, he committed this one offense, a core offense, that was really just degrees. I think the fact that we have the armed robbery and the 5th DCA certified question creates a problem because it leaves out the armed robbery. The armed robbery...
You conceded the armed robbery is separate, so you've won on that.
I have won on that, but the felony bodily injury goes with the armed robbery entirely. If there were no armed robbery, we couldn't have the felony bodily injury because no qualifying felony exists. I think it's wrong to separate them out in that regard. What the legislature intended, clearly within the statute, that they wanted separate victims.
So the attempted murder does not qualify as the felony for the causing bodily injury during a felony?
Correct, it does not. Neither does the aggravated battery. What we have here is a strict, clear legislative intent that if you try to rob somebody and you injure them, you're going to get punished. You committed 2 crimes, you're going to get punished twice.
How can you punish them twice for causing one bodily injury?
I mean, you're talking about the aggravated battery now, in addition.
Yes, right.
Right,
No.
okay. Well, he also attempted to murder.
You agree that it's the same battery?
Yes,
and
although
bodily injury.
the punch, I believe, did knock him down to his knees, and I don't know if the gunshot was fired down there or not, but
No,
that
but in
wasn't,
terms of
that wasn't
those two,
discussed below.
so help me with, it seems, if you're just looking at this logically, that those two are the two
Okay.
that probably will give us the most trouble. That is that you say he's got one bodily injury.
Correct.
Okay, and of course, that's an aggravated battery, because that's the bodily injury, that's the gun wound, right?
Well, yes.
Okay, so how can you punish them? You can say, I'm going to punish you for causing bodily injury, and I'm going to punish you for an aggravated battery. Now, it's the same, it's the gunshot wound. Now, how can you punish them twice
Well,
for the one gunshot wound?
Because fortunately or unfortunately, depending on which side you're on, the legislature and the court has determined that you look not at the act, you look at the statutory elements, and you look only at you don't look at the pleadings, you don't look at the acts, you don't look at the proof at trial. You have to look at the statutory elements. Now, felony bodily injury requires only slight injury. A strong arm robbery where you rip a purse off someone's shoulder, they fall and scrape their elbow could be sufficient. I mean,
But let me ask you this. If you just look at the statutory elements, how do you ever get to the exceptions that are listed in 775.021?
well, the elements.
I mean, because Ms. Ryan says that if you look at Blockburger, and which is the first part of that statute, you've got 4 separate crimes here, no doubt.
Correct.
Okay.
Okay.
So what's the point of the 3 exceptions that are listed if you never look at the statute, you never look at the proof or at what was alleged?
Well, I think you have certain circumstances where the legislature, Blockburger is a rule of statutory construction, and they tell you how to do, if you don't have enough statutory authority, well, I mean, it's just, what it did was it codified Blockburger's, Carouan Blockburger's analysis.
I understand
I know.
that, but
And
the point
how-
is, if we're going to stop there, then we've made the rest of the statute, it may as well not exist.
Well, it was explained by one concurrence, and I forget which case that was, that, for instance, the offenses which require identical elements of proof deal with necessary lesser included offenses. So if it's a necessarily lesser included offense.
But isn't that the same as 3, which is offenses which are lesser offenses?
Well, which subsumed by the greater, which means it has to be one removed, and that was explained in that same concurrence as permissive lesser included offenses may qualify under that. And so, and then of course, then you got degrees of the same offense, which is being argued by appellant.
I guess I've always looked at degrees of the same offense as things like murder, which is obviously separated into, first degree murder,
Several
second
degrees.
degree murder, third, then you have, grand theft, I think has some degrees
Several
of
degrees
grand
also.
theft. And I guess I've always looked at that as, but obviously the argument here is that means something more than that.
Well, that's my initial reaction as well, as far as looking at the degrees, but I think what you do have to do is you have to look at whether, as you did in sermons, or as was done in sermons, whether it's the same offense and just aggravated.
Would you agree with Justice Kogan's concurrence that that's how the exceptions are to be applied?
Okay, it was Justice Kogan. I disagree with the core offense analysis overall, because, I mean, that's really the only place that comes from, and I think that that's a misnomer and shouldn't be applied pursuant to everything else that's out there. But his analysis of where the exceptions are found assist someone in trying to understand
Do you think that the third exception is for permissive lesser included offenses?
I think perhaps, and I think in this situation too, we've
But
got...
then if you concede that, then you have to concede that you have to look at the allegation and the proofs in order to get to a permissive lesser included offense. Don't you?
Well, yes, you do. I will agree with that. I think that what I was speaking of earlier is where you don't have to go down that far. You stop at Blockberger. You stop at the very, in this case, under these facts, you've got clear legislative intent. Don't really have to go any further than the first step. If you do go down, the state's position is that they went anyway, and that if you want to look at that one act, and if you want me to proceed, we've got aggravated battery requires, in this case, it was charged as permanent disfigurement. I mean, it was great bodily harm. It was a serious injury. He'd be scarred for life because it was transverse shot, I think, through the chest and the backbone.
But it was with the firearm. I mean,
That was with the firearm,
sure,
correct.
it wasn't for the broken nose.
Or the falling down, no. And that's what's required in it, along with an intent to do that. Now, felony bodily injury. My problem is that it requires only slight injury, and that's fine, but you won't have it in every case you have great bodily harm because it requires a separate enumerated felony as one of its elements. And I think that's what separates it out. Clearly, he couldn't have been charged with felony bodily injury if he had not committed the armed robbery as well.
Isn't it better, I mean, for ease of this all, if the legislature thinks, and they did this certainly with 1020 life, and I don't know how 1020 life affects all this, but that when you're talking about, it's worse if you do a robbery with a firearm, and it's even worse if you do a robbery with a firearm and someone's injured, and it's even worse if they're injured severely. And so what you do is say, well, those are things that go to the sentencing phase to go and say, this is the sentence we want to give, because that's really what we're concerned with, that somebody serves a long sentence for doing something like this. I think my concern is that by putting this into, there's one gunshot wound, and we're going to have 4 different offenses, that we've just really put the whole thing, we've muddied it up, because it depends then, I mean, if it's only Blockberger, then we stop, and Sermons and the rest of the exceptions, as Justice Quincy says, is irrelevant. But I don't know how, based on all the case law, we can stop just at Blockberger, and unless you're saying it's based on Blockberger plus, if the legislature says, we will punish these 4 crimes, it stops at that. Is that what you're saying? That's what you're saying essentially occurred here?
That's correct. And I think that you should look at the other alternative.
So if the legislature said, listen, even if the guy was killed, which at this point would put aggravated battery and causing bodily injury would be subsumed into it. If the legislature says, listen, if you shoot the person 2 times before, we want those counted as batteries before the death, that would be okay under double jeopardy analysis?
Well, no, I think you're correct. The aggravated battery would be subsumed into the first degree murder. I wouldn't agree as to the felony bodily harm.
Well, why? Maybe by the time when you did the first shot, you really weren't intending to kill the person, you just wanted to harm them, but by the time you got to the 3rd shot, your intent to change, or you had felony murder. Why wouldn't that be?
Well, then it probably wouldn't come up that way. I mean, it would be the jury who would determine that. The jury would determine whether or not he, aborted his attempt. But I think what we also have to look at is the alternative. Carowan, which clearly has been overridden. You've got state versus, you've got everything. State versus Smith, I think it was. Several acknowledgments that the case is no longer viable because of what the legislature did. Well, Carowan was attempted manslaughter and aggravated battery. Under the facts of this case, the attempted first-degree murder and the aggravated battery, if you rule as in Carowan, we will be back to square one. I think we have evolved, and I think the 5th District Court of Appeals analysis was an excellent analysis. I think they went through it step by step. And I think the reason why we have 4 charges, next time we might have 5 or 6, I think that's all guidelines. Pre-guidelines, that wouldn't have happened. A judge could look at the fact in this case that the guy was giving up his wallet. There was no need to shoot him. It was a completely, he said, I'm giving up my wallet. Here, you can have it. He shot him anyway. A judge would look at that and say consecutive, maximum, and would be able to have some flexibility there. Now prosecutors are faced with the fact, well, it's simply a score. And if we to get what we want out of the guideline score sheet, we'll have to charge it as best we can with as many offenses that are legal and viable so that we can get to where we think it should be. And that's prosecutor discretion. That's a factor of the guidelines because it's a plug-in and score. And a judge can't depart the guidelines just because the guy shot him unnecessarily. The attempted murder, the shooting, the injury, all of that was unnecessary in this case because he said, I'm giving up my wallet, I'll give it up.
So the effect of the 5th District case is that he's now been sentenced to 276 months with a mandatory minimum of 3 years and another 60 consecutive months with a consecutive mandatory minimum. Would the effect of the 5th District's opinion be to have sentenced him also on 2 and 3 consecutively? But that can't happen. I mean, can that happen? Is that what's going to happen now?
Well, I don't know what will happen, I'm not sure, but the judge was reticent in the first place. It was the trial judge who refused to sentence on counts 2 and 3 at all. He may do that again or just do a concurrent.
But legally, he can
Legally,
issue
he can.
consecutive sentences on all 4 of these.
That's correct. He
You
would
do,
be able to.
do you agree with the case law out of this court that says that you can only have one manslaughter conviction out of a single death?
Yes. Yes, I do. But I also think that in this case, he committed, he committed those 2 offenses. If he had just done an armed robbery and committed a great bodily harm, or if he had just committed the attempted murder, the aggravated battery would be gone, there'd be no armed robbery, there'd be no felony battery. But the felony bodily injury travels only with the armed robbery.
I guess that's where I'm seeing 3. I'm just still having trouble seeing 4 from what you're saying there, but I guess you're doing it by, again, taking 2 and putting it within as a variant of 4.
It is because the legislature specifically said if you commit, in this case, a robbery and you hurt them, you are going to get a separate first-degree felony. It will be separately, victim points will separately be assessed.
Okay, so that's why, I guess, why is an aggravated battery causing great bodily injury with the firearm part of causing bodily injury during a felony?
Well, because the felony bodily injury is a felony murder, felony robbery, so to speak. It's a strict construction of the legislature. It's there, evinced an intent, you get punished for the robbery. Now, so I think you have to take them out of the picture and compare then only what you have the left as attempted first-degree murder and aggravated battery. They aren't in the same statute. They aren't lessers of each other. One's a fiction found in the homicide statute, actually.
The attempted first-degree murder.
Attempted first-degree murder, and the felony bodily injury, I think, also is found within that because they use the felony murder statute for the enumerated felonies. So that's where it's found, but it certainly isn't a lesser included of attempted first-degree murder. And if you want to do the elements, you could, I can shoot at anyone and miss. Well, the legislature wants me to be punished for the harm I caused by not missing. That's another offense. That's aggravated battery. I will agree at the well, I do have a few more minutes, and I can't come back up here. The aggravated battery is the most susceptible of them all to be subsumed somewhere, but this court has repeatedly held in State versus Boyven, which is an interesting case that's cited in the briefs, attempted first-degree murder, aggravated battery. This court held, as it has in several cases, each requires proof of at least one fact that the others do not. But in this case, you sent it back and said, we have no legislative intent or recognition that they want multiple punishments. Well,
what?
2 years after that, the legislature spoke.
In the standard jury instructions, aggravated battery is a Category 2 lesser included offense of attempted first-degree murder.
Correct.
And so wouldn't, under the analysis and Justice Kogan's concurrence in sermons, wouldn't that make aggravated battery and attempted first-degree murder, wouldn't they be degrees of the same core offense?
That's the closest of the 2, but the prosecutor, and I think intentionally in this case, charged permanent disfigurement, great bodily harm, aggravated battery. And I think that takes it out of attempted first-degree murder realm. They aren't remotely the same because you don't need an injury. All you have to do is fire at someone and miss. Aggravated battery, you got to intend, and you've got to cause, in this case, great bodily harm. So a battery element is not involved in the attempted first-degree murder. And ironically, it is involved, of course, in murder. And then an aggravated battery would go away if this had been a murder, if he had died. So he's subject to less, subject to more for doing less, so to speak, more offenses. But it's permitted by statute. The legislature's intent is clear that we want to punish for as much as we can. I think that's a byproduct of the guidelines. I don't think there's any question that Carawan has been overruled, and the elements test in this case would support the 5th DCA's opinion, which was well done. Thank you.
Thank you. Rebuttal?
Judges, I have 1 minute, and I apologize for not making the larger issues clearer. In my first 19 minutes, I've got 3 small issues, which I believe I can make clear in this last minute. First, I do not have the information with me, but all of my notes indicate that this ag battery was not charged as a permanent disfigurement, but was charged as great bodily harm. Second, as to the punch, the language I was referring to from the 5th DCA appears in the second paragraph of the opinion. The court expressly says there was no evidence of injury from the punch. So we are talking about the gunshot as the basis for all the offenses here. And also, the justices today have been referring to Justice Kogan's concurring opinion in sermons as the basis for the core offense test. I'd like to refer the court to State versus Anderson, a 1997 opinion from this court, which is cited in the petitioner's briefs, in which the entire court did adopt the core offense test. Is court any further questions?
Thank you very much. We'll be in recess for 15 minutes.